Great. Well, thank you everybody for joining us today. I know others will be joining us as we go along, but I don't want to, since everybody's on, we'll get started at 11 o'clock. Thank you, Andrea, for joining us again to discuss the impact of the new Pennsylvania salary thresholds. Andrea is with Post Schell. She actually delivered a wonderful webinar yesterday. You should check it out on our website regarding navigating vaccinations with your employees. But today she'll be discussing and examining the specific parameters around the DLI's regulations and the impact on employers. With that, I will turn this over to Andrea to continue the webinar. And as always, real quick, just keep your mics muted and use the chat feature for any questions. We'll address them at the end of the webinar. Thank you, and it's all yours.
Thank you very much, Hope. And thank you for everyone for joining. I appreciate you taking the time to talk about these important topics. My name, as Hope said, is Andrea Kirshenbaum, and I'm chair of the Employment and Labor Practice Group at the law firm of Post Schell. And I spent a significant portion of my practice counseling clients and handling litigation in the wage and hours space. And we're here today to talk about the quote, I'll call it the new Pennsylvania salary thresholds. They came out last October, but they're really, you wouldn't have felt the impact until this coming October. So I'm sure that when I say salary threshold, your eyes glaze over, and it's just been a whole roller coaster ride with the salary level. And just so that you have a sense of where we are now, I think we need to go back in time and just very briefly go over how we found ourselves in this moment, because what happened at the federal level really informs what you all are dealing with at the state level at this point. So as many of you may remember, during the Obama administration, the Department of Labor Wage and Hour Division proposed significantly raising the salary level. It was at $4.55 a week. And so it was essentially doubling that salary threshold. The regulations went through. They were scheduled to take effect December 1st. And then just a few days before they went into effect, they were enjoined nationwide by a district court in Texas. And there was litigation that went on with regard to the 2016 Department of Labor salary increase. And ultimately, those regulations never did go into effect, although many organizations in preparing for those changes did a lot of work to analyze what the impact was. And so just to take a step back, just so that we're all on the same page, what we're talking about today is what is colloquially referred to as the white collar exemptions. And this is under both federal and Pennsylvania law. So in order to not have to pay overtime for employees under federal and state law, you need to meet multiple different requirements. And I think about it as like the three legs of a stool. And so if you don't have all three, the seat falls and then you have to pay overtime. So number one is you need to satisfy the duties test. And we're not going to spend a lot of time today talking about the duties test, although we'll talk about it a little bit. So if you have an executive, for instance, the person needs to oversee a certain number of workers, and overseeing workers needs to be their what's called primary duty. Okay. The next part is the salary threshold, which is what we're going to be spending most of our time today talking about. And so the assumption is under the law that if the worker is not paid X amount on a weekly basis under the salary threshold, they have to be eligible for overtime. And then the third piece is that that amount of pay can't be subject to regular deduction, and there are all sorts of intricacies with that, which again, we're not going to spend any time today talking about. So the U.S. Department of Labor, in increasing the salary level, basically said that the salary level should be the proxy. And so if someone is below, they have to be paid overtime. And the district court in Texas basically said, no, that's not the way this law works. the focus is the duties. And by having such a high salary level, you're essentially supplanting or preventing the focus on the duties. So after this happened, all these organizations revved up to get ready for these regulations, and then they didn't go into effect. Several things happened. Some organizations kind of left it be, and people who had been reclassified, they kept them that way. Other organizations, seeing that the regulations didn't go into effect, went back and made some additional changes. But as this happened at the federal level, various different constituencies in different states basically said, look, if we're not going to get satisfaction from the federal government on this salary threshold, maybe we need to go and start working with the individual states. So that sort of started to percolate. And then, during the Trump administration, we got these new additional regulations from the US Department of Labor. And as you can see, the final regulations set a new salary threshold of $684 per week. So that's obviously, just going back real quick, much lower than this $913. So this $684 is now the federal threshold. So after the DOL regulations in 2016 were enjoined, again, as I said, many states tried to fill the void, and Pennsylvania joined the fray in 2018. So back then, the Pennsylvania Department of Labor and Industry, or as we often call them, L&I, published a proposed rule in the Pennsylvania Bulletin. And that contains new proposed minimum salary thresholds for the EAP, what we call the EAP, the Executive, Administrative, and Professional Exemptions. So, or again, we call them sometimes the white collar exemptions. So those numbers were pretty high, and it was over 3 years. And that was in part the same model that the US Department of Labor had used. The very controversial aspect about the US Department of Labor regulations was also what people called, quote unquote, automatic increases. So not only did it raise the level to X number, but it set in place a process where that number would be automatically, quote unquote, updated every 3 years based on data from, that was identified that should be used. So this $921 a week was proposed in Pennsylvania, and there was a lot of opposition. Number one, some of the data relied on the Northeast, which wasn't specifically only Pennsylvania, also included New York, which, concerns were that it overinflated the number. And this was slightly higher than the federal number. So there was a lot of opposition. Ultimately, those regulations didn't go into effect. And I have up here what those proposals were. And again, the proposal of the automatic increase was at the 30th percentile of earnings for the entire Northeast region. So not just Pennsylvania. So this was what was proposed in 2018 that did not go into effect. So then, after those regulations were proposed, then we got these new US Department of Labor regulations, which increased the number to 684. And so Pennsylvania went back to the drawing board and said, okay, well, now we have this 684 number. What are we going to do? And the Department of Labor and Industry proposed what I have up here on the screen. So this is the final rule that went into effect last year. And not coincidentally, the level in Pennsylvania went up as of October 3rd. And the reason why it's October 3rd and not some better date like January 1st or something like that, it's just when it was published in the bulletin. So that's why it is that way. Though, many organizations organize things based on a calendar year or a fiscal year. So doing this on October 3rd, it makes it more complicated for many businesses, and we can talk about that. So as of last October 3rd, essentially Pennsylvania law matched federal law. So it was a paper change. The final rule went into effect, but the $684 per week, which is equating to $35,568 per year, is the same number, right? But the model, again, of the Pennsylvania rule is the prior federal rule. So it's 3 years of step increases and then that automatic, and I say automatic because it doesn't happen automatically, you have to look at data, but the automatic in that it doesn't require additional regulatory approval. So here's where we are right now. So October of 2021, so just a couple months from now, the level will then increase from that $684 per week to the $780 per week, which equates to $40,560. And then a year after that, the increase is going to go to $875 per week, which is $45,500. So these numbers are based on only Pennsylvania data. So the Department of Labor and Industry, in response to concerns about using the whole Northeast region as the relevant data, went back and pulled numbers just for Pennsylvania. So that's why you're seeing slightly lower numbers here, because again, it's not taking into account, submarkets where pay might be higher, like New York. So here's where we are at this point. You all now are staring down this $780 per week. So practically, what does that mean? That means that if you have any employees who are currently classified as exempt from overtime, as either administrative, professional employees, or executive, so if you have anyone in that category, so someone who's making between $684 per week and $780 per week, you then have some decisions to make, right? So as with when we looked at this on the federal level, if you have someone making in between, you can increase their pay on to over the $780 per week, and then they would have that salary level. You still need to make sure they meet the duties requirements. So you may want to use this as an opportunity to analyze whether someone is continuing to meet the duties requirements. And then you have to make sure that they're not subject to deduction. But it's not just the $780, because then you're looking at an increase at $95 per week a year from now. So that should influence how you think about these issues, because the number is just going to increase. And then on October 3rd in 2023, and then every 3 years thereafter, we're going to see an increased number as well. So then you have to make a list of all the people who might be, in these categories, or, if you want to do some proactive planning, it probably makes sense to also look at someone who's making $800 per week because of what you have going on. And then you have to assess, how do you want to proceed? Do you want to increase their pay in order to avoid the obligation to pay overtime? Do you want to reclassify the person as eligible for overtime? And then, that creates a whole cascade of other questions. So if someone is classified as non-exempt, then you need to make sure you're tracking their time and give them training on whatever mechanism you use to do that. And I know that there are many people on the call today from destination marketing organizations, and I'm sure you all are chomping at the bit to do things in person and have events. And so the concern is, how do you manage the hours of folks who are going to these events? And so it's a complex set of questions, but, the concern I would have with just increasing the pay is that it's not just this 1 year, you're looking at 2 additional increases afterwards. So then you really, if you're looking at reclassifying, then you need to make sure that you have mechanisms in place for folks to report all of their time worked. You have to be more careful with respect to the hours of those people, making sure that you're addressing any obligations you have to pay for travel time, and those regulations are an hour-long webinar in and of themselves. And then if you have marketing folks or other folks that are going to trade shows or other things, know that if they're working substantially more than 40 hours a week and they're non-exempt, there are going to be significant overtime obligations. And so that will impact how you think about staffing, whether you want to break up the duties among other people, that sort of thing. So it may affect how you set an hourly rate for the person based on the number of hours that they previously have been working. So there are many steps to the process in evaluating these questions. If you have someone who typically works 38 hours a week, it's not going to be a significant issue. But if you have folks who are working substantially more than 40 hours per week, then you have to assess how many more than 40 are they working, and that will impact how you set their rate of pay if they're currently salaried and you're thinking about making them hourly employees. So the triennial increases, so the increases that are the first one's going to happen on October 3rd of 2023. Then the next one's going to happen on October 3rd, 2026. Those triennial increases, it's tied here to the weighted average of the 10th percentile. So it's lower than before. Before it was the 30th percentile for Pennsylvania workers who are working in these types of positions. So executive, administrative, or professional positions, as determined by the department meaning the Department of Labor and Industry, with advice and consultation by the Minimum Wage Advisory Board, and based on an annual wage survey of all worker classifications. So we're going to have to stay tuned as to that data. The thing that is also, and again, you're focused on this October, but just so you see it coming down the pike, it says that the updated salary level is going to be published at least 30 days prior to the effective date of each 3-year period. As you all know, 30 days is not a lot of time, and you all are financially forecasting a year, 2 years ahead if you can. So it makes it very difficult to plan when you don't know what's coming down the pike on October 3rd of 2023 and every 3 years thereafter as to what's going to happen with the salary level. Obviously, we're going to see what happens the first instance. Hopefully, the Department of Labor and Industry will try to get this out long before the 30 days to help organizations plan, but that's just another thing to be aware of. I think that many organizations, when the Department of Labor initially, the US Department of Labor initially issued their regulations, I think reflexively, many organizations said, look, I'm just going to increase the salary level of, Joe and people working in Joe's position so that I can avoid the obligation to pay overtime, which is going to cost me a lot more money. It's also going to be a lot more variable and it's much harder to plan. So I think that some organizations reflexively did that. And I think that before going down that route, especially because of this level increase over the 3-year period, and then the automatic increases, that organizations really need to be mindful that this is step one in a multi-step process. So if you increase the salary level to a point where it's over the 780, you're still staring down in a year's time that 875. So that is a temporary fix. It's not a quick fix, and it's not a permanent fix. So that's something to think about as you're making these decisions, because I think that it makes it more likely that you're going to need to think very seriously about reclassification of exempt employees to become non-exempt. And I think there are a series of challenges with that. I think, while the goal in doing all of this is to give opportunity for workers to get overtime, really, a lot of folks are very invested in being exempt employees, having some additional ability to be flexible with their time, so that they don't have to clock in and clock out. So if they have a doctor's appointment in the middle of the day or some other commitment, that they're not watching the clock, so to speak. And people take pride in being a salaried exempt workers. So there's a whole employee relations component involved in reclassification that some folks really struggle with. So these are sort of the things that you all should be thinking about as you're thinking about, should we reclassify? Do we need additional assistance? How do we set the hourly rate of pay for this person, given that we expect them to work X number of hours of overtime? It seems like October, especially in the pandemic, I feel like every month feels longer. So October feels like it's a long, long time away. But when you're having to plan for these issues and put in place additional timekeeping mechanisms, train people on the timekeeping mechanisms, train managers on the timekeeping mechanisms, I think that it's important for organizations to start thinking about these issues now if they haven't already, because it's June and October, unfortunately. We're all looking forward to summer and thinking about the summer, and it certainly, you look out your window, it certainly feels like summer right now. October is not that far away. So I have up here, the final rule numbers. These are the numbers you should be thinking about. But again, as you're planning, you should be thinking about what that 875 is going to look like a year from now, and not just what the 780 is going to look like as of this October. Other significant things to note. So the Fair Labor Standards Act, the federal regulations that went into effect, and this was also in the 2016 proposed regulations, up to 10% of the salary amount required can be satisfied by the payment of non-discretionary bonuses, incentives, and commissions that are paid annually or more frequently. So you just need to keep track of that. So if you want to take advantage of that 10%, you have to make sure that at the end of the year, you're truing up that, if you're paying people 90% and they haven't earned through bonuses, incentive pay, or commissions that 10%, you then need to top them off, because if they're below that level, then they would have been entitled to overtime the entire period of time. And that's going to create all sorts of issues for people who are working more than 40 hours. So there's the test. The other thing to think about is the test that used to be in place. So if you think about the Pennsylvania Minimum Wage Act, and you think about the Fair Labor Standards Act, the Pennsylvania Minimum Wage Act relied on the Fair Labor Standards Act and used it as a template. But it's like, think about two diverging roads. So the Pennsylvania Minimum Wage Act relied on the older version of the FLSA. The FLSA before 2004 had two different tests, and I'm not going to get too much into the weeds with this, but it was a different duties tests. So in 2004, when the US Department of Labor revised the regulations and got rid of those tests, the Pennsylvania tests never caught up. So now this is just a catch up. So now the Pennsylvania regulations look a lot more like the federal regulations. They've simplified the test. And so that's something to consider. So it looks a lot more like the federal regulations than it did before this facelift. But it's also important to note that even though there was a conscious effort to conform Pennsylvania law more closely with federal law, it didn't go all the way. So there are still some very significant differences between the Fair Labor Standards Act and the Pennsylvania Minimum Wage Act, which remain to this day. And I think a lot of organizations, they're so focused on what the federal law says, and there's sort of an assumption that in Pennsylvania, the law is the same, that they lose track of a couple of things. So it's always important to know that you have to comply with both. As many folks say, the federal law is the floor and not the ceiling. So Pennsylvania can have more protective legislation. And that's frankly what we're talking about here. What Pennsylvania is doing is above and beyond what the FLSA and the US Department of Labor requires. So in that vein, Pennsylvania does not have a computer professional exemption. Doesn't exist. Pennsylvania also doesn't have what's called a highly compensated exemption. So folks that make over a certain amount of money, the duties test is relaxed. So those are just other things to keep in mind, that Pennsylvania law and federal law are not the same in this area, and to make sure that you're checking as to what it is that that needs to happen. So that is the formal part of my presentation. My sense is that you all have lots of questions as to how to implement the change in October. And so I wanted to make sure that we had a lot of time to go over the questions that you had, and I can talk through them with you and help you to strategize how to proceed under the circumstances.
Thank you so much for that presentation. If you have questions, you can put them into the chat, or if you wanted to unmute yourself to ask the question out loud, that'd be no problem at all either. We don't have that big of a group, so I think we'd be able to control that.
I think that.
And as always, oh, sorry.
I'm sorry. Go for it.
Oh, no, I was going to say, as always, we will be sharing this and sharing Andrea's, her contact information, so you can reach out to her. But please, ask some questions today, because some others may have the same questions, and they're feeling shy to ask them.
Yeah. And I think that the reason why people are starting to ask these questions now, I think that people did not. Last October, this was not the focus of people's attention. So I think a lot of organizations, this just didn't catch their attention. And now that we're coming out of COVID and we're staring down enforcement of this in a few months, many organizations are trying to catch up now that it's not all COVID all the time.
Agreed. Lisa, did you have something you wanted to ask?
Yeah, actually, I do have a question, and this is getting more into the nuts and bolts of implementing this. But I'm a destination marketing organization, and as you had mentioned earlier up in your presentation, we are dealing with staff attendance at trade shows, staff travel. When are they on and off the clock? We are involved in a lot of events, so there are times where there is a lot of overtime, but it's not that way necessarily all the time at certain times of the year. But I guess that's what I'm trying to get my head around more so is, when somebody leaves on a Sunday to go to a conference or to a trade show, when are they on and off the clock, and I guess how do we account for that? Or, you had mentioned even if somebody leaves for a dentist appointment and they clock out, but they may be on the phone with customers or handling work-related calls and emails while they've clocked out. It's, it just really is not that, black and white in the world that destination marketing organizations live in.
Yeah, no, I think that, and those are a lot of different questions, and that's absolutely the series of issues that you have. And it's fraud because, and it's ripe for litigation, especially if you have a lot of people all in the same job classification. And so I think, what I would say is with respect to travel time, there are different rules and regulations as to whether you're traveling all within a workday, if you're outside of your primary community, if it's within the time you would be working or outside of that time. And so there are, as helpful as they can be, there are pretty helpful fact sheets that the U.S. Department of Labor has that tries to walk you through what is or what isn't compensable. I think what many organizations struggle with is, well, so how do you put in place a general policy when you have all of these different iterations and situations? Many organizations, in order to avoid the legal issue, will pay people in situations where it's a gray area, where it's unclear whether you need to pay or you don't need to pay. I'm involved in a litigation right now where there are allegations, again, along the lines of what you're saying, that during travel, people were on the phone, people were talking about work. There are all sorts of doctrines that have developed under the Fair Labor Standards Act, and in many instances are applied under Pennsylvania law. One of them is called the continuous workday. It will be very interesting to see what happens with the continuous workday, given, what we've gone through the last 15 months. But the doctrine used to be that as soon as you start your first principal activity of the day, if it's, talking to someone about the schedule, or, someone calls you on your drive to work about something, that begins the start of when you're, quote, on the clock. And then the last acts that you have, the end of the day, that stops it. So if you have a significant block of time in the middle of the day where you're off the clock, is it part of the continuous workday or not? I think that, during COVID, the U.S. Department of Labor, because many of us were working remotely, said, look, the continuous workday is not necessarily what you need to rely on if someone needs to take an hour and a half off and help their kid with remote school. So I think that we may see some additional development in that area of the law, but it's a lot of different questions that you need to answer, and it's problematic. But I think that nothing with respect to the salary level here implicates any of that analysis, unless you have someone who's making under this new salary number. So the other thing that I want to mention, and I think it's important, is that I think now is a time for organizations to really look and say, is this person properly classified? As you're going through the process and making changes, now is a good opportunity to be looking at that question. Because if you have an entry-level marketing person and they're not making decisions that require significant what's called discretion and judgment, then it may be that they should not be an exempt employee irrespective of the salary level. So I think that now is an ideal opportunity for organizations to, dust off those job descriptions and really take a hard look to assess, is this person properly classified? And I'm happy to share some specific travel time guidance. If you want to reach out to me individually, I can send you some guidance documents on travel time.
Thank you, Andrea. A question did come up in the chat asking about if you knew of any webinars about minimum wage in the service and hospitality industry. I'm not sure if she's asking if you've done any webinars. Kathleen, I don't know if you could.
Not necessarily if you've done them, but if you know one, I guess we misunderstood a little bit that this one was more focused on salary, and we are a bar restaurant, and we were looking for more information on what's happening with the minimum wage and wages in the service industry and what will be required in that time. Because July 1st, the minimum wage is going up again, I suppose, right, to 12?
So you're talking about the Pennsylvania minimum wage?
Yes.
Yeah. So, minimum wage is a relatively straightforward concept, right? If, when the minimum wage is increased, you need to make sure that your employees are making at least that minimum for the hours that they work. But I think in the hospitality industry, the issue is more complex because you have to deal with tip pooling and tip credit issues, right? So that's often the issue. So that's a complex area, very complex, and it's an area that's in transition right now because there was a change in administration and some regulations that were issued have now been pulled back. And so now we're in a waiting period to figure out what are the new rules of the game going to be. There's a lot of litigation in that area and a lot of uncertainty.
Right.
So, but as of now, the Pennsylvania minimum wage is what the federal minimum wages is at $7.25. So that's what I'm aware of at this point.
I was put under the impression that because it's service and the tip factor, that you don't necessarily have to be at minimum wage as long as your employees are proving that they make minimum wage with their tips included. Is that not a real thing?
So the tip credit, yes, the tip credit is permissible, but there are all sorts of requirements in order for you to take the tip credit. You have to provide your employees notice in writing, and there are all sorts of, steps that you need to take. And if you don't take those proper steps and you don't document that you've given that notice and that people have signed off, then you can create, then you have a problem.
So that's the nitty-gritty of like, do you know of any webinars that are talking about that detail right there of how you comply to that if you were going to, and what it takes, just so we can weigh it out? Because obviously $5 an hour is quite a big jump.
Yeah, no, I totally understand what you're saying. It's, I think that you should be careful not to rely on anything that was done before 2021, because this is an evolving area. And so it's not settled. And so what everyone thought the law was, a year and a half ago, a bunch of regulations have been withdrawn. And so I think you just need to be very, very careful. So that's the first thing that I would say. The second thing I would say is that we're in an area of transition right now. And so, and this is the worst thing to tell an employer, so I apologize in advance for saying it, that there's not a significant amount of clarity in this area right now. Because of the changes. And so and there really are two tracks that you're operating under. Number one, you have the U.S. Department of Labor's regulations
Mhm.
and the requirements. And then, obviously you have Pennsylvania overlay on that. But then you also have cases that have been decided that, interpret those regulations and, who can and can't be in a tip pool, front of house versus back of house. And so if the tip pool, if there is tip pooling and, there are a couple people in the tip pool that are challenged that they shouldn't be in the tip pool, that may invalidate the whole tip pool. So it's there are a lot of different intricacies and again, a lot of opportunities to foot fault. And I know that that's an area that people are very interested in. There's not one specific webinar that I could identify for you that's been done in the last couple months.
Okay.
But I would say that I would look to see what the National Restaurant Association has put out to see if there's any guidance there to help.
Okay, thank you.
And Kathleen, I'm going to put my email into the chat. If you could
Okay.
email me some of the questions you have, I may be able to have Melissa respond back to you, our VP of Government Affairs, on some of the things that she's talking about, what's going on, and we may be able to address some of it. And
Okay,
we will be doing future webinars on, other these types of topics. So I'm going to put it into the chat, and if you could just, send me some of your questions, we can see what we can do to help you out too.
All right, thank you so much.
Yeah, but I appreciate the confluence that this is that the minimum wage is causing you to reconsider. Yeah. Yeah.
Great. Well, do we have any other questions? Again, you've done such a good job. Again.
Yeah, and I'm looking here because I guess I know that Governor Wolf announced a plan in April that would see the minimum wage rise to $12 this year. So I'm just looking to see, because I don't know whether that ultimately was passed. So I think just make sure that you're relying on current and accurate information.
Yeah, and that's what, if you can send me that information, Kathleen, we can make sure that we get clarification on everything for you.
Yes, will do. And maybe I should just look it up again. I thought just a couple months ago that I saw that they did decide that July 1st that it was going to go to 12, and then it would be 50 cents a year after that until it got to $15.
Yeah. Yeah, I mean, I know that in March and April, the governor was making a big push to increase the minimum wage. Yeah.
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 Okay, well, thank you so much.
No problem. Does anyone else have any other questions about the salary level? I'm really interested from hearing from all of you as to what level of people you're thinking about. Are these like your frontline marketing folks, or who is it that's sort of caught in the in-between level that currently is going to be classified as exempt that you're now having to relook?
You're welcome to unmute.
I'll
Trained everybody.
Yeah, I can jump back in. Our DMO is a small organization. We're a full-time staff of 6 people. And really, we've all traditionally been salaried and exempt from the get-go. So we've never tracked anybody hourly just because of everything that we do. So I have two of us of the 6 are over the threshold, so there's no issue there. I have 4 people who will be under it as of October, and 1, 2, 3 of them are on the marketing side of things, and then one is on the administrative side of things. But we all handle so many different responsibilities that really everybody is marketing in some way, shape, or form. So yeah, so 4 of the 6 are going to be caught in that threshold.
I would just say, first things first, definitely look at the duties, because, I often think about classification, not necessarily with respect to one person, but as part of a broader organization. So if you have an entry-level person who's administrative and is not making decisions with respect to matters of significance, which sounds, I know this sort of like legalese, but there's sort of an art, it's more art than science. But, if someone is deciding, which caterer to order from for the event, that's probably not going to satisfy the requirements. So I think it's important to know that it's not just the salary level that you need to satisfy. You also need to satisfy the duties requirements. And if every single person in the organization is exempt, then that may raise a red flag, because who's making the decisions that are, who's the low person on the totem pole, and what are they doing? And is it really true that they're meeting the duties test for either the administrative or the professional or the executive exemption?
Mm-hmm. Thank you.
Yeah, no problem.
A question did come in around regarding non-exempt employees, and who, so if a non-exempt employee who does work beyond their 40 hours in 1 week, am I permitted to offer her comp time?
So if you are not a state or local government entity, then when you say comp time, that's what it's like a term of art, comp time. So you can offer additional time off in another week, right? But if someone works at a conference Monday, Tuesday, and Wednesday, and Monday through Thursday, and they have already gotten up to their 40 hours, you can give them off Friday, and then, pay them. And if they make more if they're over the 40 threshold, you have to pay them overtime. But you can't say to someone, you worked in week 1, 50 hours. And so in week 2, I'm going to give you 10 hours of quote unquote comp time off. That violates the Fair Labor Standards Act for private employers. So it's really specific to the work week, and employers can define the work week however they want to. They can't keep changing the definition of the work week. And if you change it, then you need to provide your employees with notice that you're changing the work week. So if you typically have conferences on a certain, that span, Wednesday, and it's more favorable for you to think about not having the work week being Sunday to Saturday, you can think about doing that as a mechanism for dealing with some of these issues. You just can't keep changing the process. But you have to look at overtime and eligibility for overtime on a 7-day cycle from the start to the end of the defined work week that you have. So.
Great, thank you.
Yeah, no problem. Yeah, I think that there's a misapprehension that comp time is permissible, and if you're not a governmental entity, it's not.
As a follow-up, she was asking about a 7-day cycle and not a pay period.
Yeah, so there are no healthcare employers, I'm sure, on this call. So we're putting them to the side because there's a special exception for certain healthcare employers. You have to look at work week by work week and not pay period by pay period. So if someone works 50 hours in week 1 and 30 hours in week 2, the employee is still entitled to 10 hours of overtime. So you can't combine for the pay period and then divide it.
Laura, did that answer your question?
Yes, sorry for the anonymity here, but I am on vacation at the moment and there's a lot going on in my background. But
Oh,
thank
no,
you.
no problem.
Yes, that does answer my question. Thank you.
And
That's-
Linda is, oh, I'm sorry.
Oh, I was saying that's commitment.
I
Dialing in
know.
on vacation.
Linda
Yeah.
has a question about back when Obama was working on these changes, we redefined our work week as Sunday to Saturday and then scheduled our hourly employees as needed. And we dropped the words comp time. We still have a challenge with travel regulations. If they're waiting in an airport for 4 hours, is that paid time?
So this is everyone's favorite lawyerly answer. You're gonna love it. It depends. So it depends on when the time happens, right? So is it happening on a Tuesday during their regular shift, or is it happening on a Saturday outside of their regular shift? And so it's very situation specific, unfortunately. And so there's no blanket answer to that question. I'm sorry. What I would suggest is that you look at the Department of Labor has a bunch of fact sheets, which generally are written in plain English and are useful, but there are several that deal with travel time issues. And one of them is fact sheet number 22. You may want to look at it. So it says that time spent by an employee in travel is part of what's called the principal activity, such as travel from job site to job site. That has to be paid. But if you're traveling, quote, away from the community, the guidance says travel that keeps an employee away from home overnight is travel away from home. Travel away from home is clearly work time and it cuts across the employee's work day, right? So if it's during the workday, they need to be paid, the traditional workday that they're working. And it says the time is not only hours worked on regular working days during normal working hours, but also during corresponding hours on non-working days. And now this is my favorite part. It says, as an enforcement policy, the division, meaning the wage and hour division of the U.S. Department of Labor, will not consider as work time that time spent in travel away from home outside of regular working hours as a passenger on an airplane, train, boat, bus, or automobile. So the problem with that is that just because that's the U.S. Department of Labor's enforcement position doesn't mean that, that it cannot create a potential issue for private plaintiffs to bring claims. So it's not as clear as you would like. So I'm sorry that I'm giving you a very unsatisfying answer.
Well, I appreciate you giving us the answer at least. The fact sheets that you're talking about, they're on the U.S. Department of Labor's website, is that correct?
Yes, it's www.dol.gov. And if you go to the wage and hour division, they have a series of fact sheets. They're not, I mean, take them to the bank. You can, you can use this in litigation. They're just sort of guidance documents, but they're helpful. They're written in plain English, and they're certainly a good start. Pennsylvania just doesn't have as developed, a series of guidance documents. And so while there are some distinctions between Pennsylvania law and circumstances where Pennsylvania law is slightly more protective. So I think that if you're dealing with hourly workers, people who are not paid a salary, some organizations have decided, just as a litigation risk mitigation strategy, that for hourly workers, they're going to pay a different rate of pay for travel time than they pay for non-travel time, which, as long as that's your agreement with someone in advance, that's permissible. So many organizations have pay $7.25 an hour for travel time, just to avoid having the legal issue and potentially, having someone assert a claim. So that's another way of thinking about these issues.
Great. Well, I don't know, we're getting close to the 12 o'clock hour, and I know, I think we said this would be, no more than an hour. I don't know if anybody has any other questions. If they don't, though, we'll definitely be sharing this recording with you. And, Andrea's contact information will be there, and you can always reach out to us if you have additional questions, and we can try and help you through this whole process. Everybody's saying thank you and that they appreciated your webinar.
Thank you very much. I hope it's been helpful.
It definitely has. And thank you for taking time out of your day yesterday and today for presenting this information to our membership. We appreciate your support.
Happy to do it.
All right, with that, we will end the webinar and hope that everybody has a great and wonderful rest of the week.
Take
Thank you,
care.
Andrea. Bye-bye.
Bye.